Hi, my name is Abhinav Lohia. I'm the Managing Director of Global Business Development at Golden Gate Global, an EB5 investment fund headquartered in San Francisco, California, with offices in Chicago and New York. I began my journey in the EB5 visa industry in 2013, first as a partner at an immigration law firm in New York. And in 2018, I transitioned to the investment side of the EB5 visa program after becoming a licensed finance professional in the United States. In today's video, we will discuss about the concurrent filing of application of adjustment of status along with the application for conditional green card. In this video, I'll be addressing a few frequently asked questions such as what is adjustment of status? What is concurrent filing for application for adjustment of status? Is an applicant allowed to work while an application for adjustment of status is pending? And is an applicant allowed to travel while an application for adjustment of status is pending? To understand the concept of concurrent filing for adjustment of status, we need to familiarize ourselves with a few terms associated with the process, starting with adjustment of status. Adjustment of status allows certain foreign nationals in the United States to apply for a green card without returning to their home country. The first step in the adjustment of status process is to determine if the applicant fits into a specific immigrant category. Concurrent filing is only available for an applicant who is physically present in the United States. And petitions can either be filed right at the time you file an underlying immigrant petition or at any time while it is pending. Also, the application can be concurrently filed when there is a visa number available at the time of filing. That is, the visa category has a current priority date in the visa bulletin issued by the federal government. For instance, if an Indian-born applicant wants to file adjustment of status concurrently, they can do so if they invest in a project that is rural or high unemployment, because today they are both current. However, if an Indian-born applicant files a petition for EB5 under an unreserved category, which is retrogressed to 2021, they cannot concurrently file for adjustment of status. Coming to the question of being able to work while an application for adjustment of status is pending, the answer is yes, provided you get an employment authorization document. An employment authorization document is something that USCIS approves while an application for a green card is pending. And the employment authorization is not dependent on employment sponsorship and can be used for obtaining employment with employers that do not traditionally sponsor work visas. Or one can start their own business or choose not to work at all because it is not dependent on employment at all. Now, coming to the question whether an applicant can travel outside the United States while an application for adjustment of status is pending. The answer to that is it depends. In order to leave the United States, the applicant needs to obtain what's called an advance parole document. And an application for an advance parole document is filed concurrently along with adjustment of status. If an applicant leaves the United States without obtaining advance parole document, they will have abandoned their application. There is an exception to the advance parole document, and that is if an applicant is in a valid L or H status and have a valid H or L stamp in their passport, they can travel without an advance parole document without jeopardizing their application for adjustment of status. Now, let's talk about EB5 visa. The EB5 visa program was established in 1990 by the US Congress. It requires a minimum investment of $800,000 in targeted employment areas and $1,050,000 outside of the targeted employment areas. It is administered by United States Citizenship and Immigration Services, and it requires creation of at least 10 new American jobs from the investment made by the investor. Also, funds should be legally sourced and documented prior to making an investment for an EB5 visa. Now, understanding the process and how it links with the EB5 visa process. So the first step, or in the journey for EB-5 visa is documenting your source of funds, which takes about 4 to 8 weeks. An immigration attorney will do that for you. And then you go ahead and make an investment. Once you've made this investment, your attorney will file an application for a conditional green card. Concurrently, they will file an application for adjustment of status, work authorization, and advance parole. Now, you will most likely receive your work authorization in 3 months' time and advance parole in 6 months' time. The timelines vary. And these two applications are important. Why? Because while you wait for issuance of your green card, you have the right to work in the United States. And the advance parole document, as discussed earlier, allows you to travel outside the United States and gives you the ability to re-enter. It takes about 12 to 24 months, depending on the project you invest in, whether it's rural priority processing or higher employment, to receive approval of your application for a conditional green card, and about another 6 months to receive your actual green card. Then you're required to file for removal of conditions in the 90-day window that opens up at the expiration of 21 months from the day you got your conditional green card, and it closes after 24 months of receipt of the conditional green card. And it takes another 3 years to remove conditions, but during this time, your conditional green card is extended for a period of 4 years. You're never out of status. And also, you can apply for US citizenship 5 years from the day you get your conditional green card. I hope this video was helpful. To view more videos about EB-5 visa, log on to our website, www.3gfund.com, or follow our YouTube channel. Thank you.